is obviously this is a rather not the most interesting subject, and we're hoping not to kill you by PowerPoint, which is typically the case, which is why we introduced a couple of videos, and we're going to try and make it as interactive as possible. There's some paper on your tables to take some notes. But what I wanted to talk to you about was mindset about this, about the POPI Act, Protection of People's or Personal Information Act. The reason I say that is data protection is actually about you and I. So each of you in this room is what is deemed a data subject, and under the law you are the ones that they're wanting to protect. So take your business hat off just for a second and don't think about the business you represent, the business that you own, the business that you run. Think of it from a personal perspective in terms of, do you want your personal information not guided by protection principles? So think about yourself in that. The rest of the world, certainly the first world countries, it's very embedded, and their laws are evolving and getting better and better all the time. Think about the mindset being not fixed on the fact that, oh, this is another thing that businesses have to do, it's another cost for businesses to do, it's another headache. It really is about individuals, ourselves, being protected going forward. So GDPR, General Data Protection Regulation, which is an EU regulation that came into effect last year, May. Malware attacks in South Africa increased by 22% in the first quarter of 2019 versus 2018, and that equates to 13,800 attempted cyber attacks in SA per day. Okay. A lot of that is coming from what they call BYOD, bring your own devices, and things like cell phones and tablets being brought into the workplace or not configured through relevant servers. And just want to read you here. In many countries, especially Africa, we see this lack of awareness of the threats to critical infrastructure. A lot of organizations are facing malware attacks, and a lot of these are caused by employees making inappropriate use of company property, including on mobile devices. Mobile is becoming a major problem. Okay, South African business underplaying the danger of cybercrime. This was the 13th of March. So there's very good reason to be very concerned, or some onlookers may be skeptical. This is far from a mere academic hysteria. Looking at the magnitude of cyber attacks and data breaches that occurred in 2018, the global cyber threat has become a very ugly reality. 2000 also marked the year in which cyber threats moved beyond software and into an insidious realm of hardware. The meltdown and spectre threats involved in weaknesses in computer hardware and that potentially affected every Intel processor produced in the last 10 years. According to the South African Banking Risk Information Center, South Africa currently has the third highest number of cybercrime victims worldwide, with the country losing an estimated 2.2 billion a year to cyber attacks. From January to August, it's reported that cyber digital banking crime has resulted in 183 million in losses, with mobile banking losses increasing by 100%. So why POPI? Data protection breaks down into the data subject, which is us, being a personal impact. The person controlling the information, or deemed under that called a responsible person, we'll talk about that more. The processor, that's someone that may process on your behalf of the controller. And then obviously transferring of data cross-border. And cross-border is not physical going across the border, that's everywhere out of South Africa, whether it be on the internet, electronically transferred. Obviously, why POPI? Good governance, reputational protection, and doing business with the rest of the world. There's a lot of countries lobbying South Africa, outside of South Africa, saying we don't want to do business with you until you have decent data protection. There's internal lobbying going on from companies saying we need to get our data protection sorted for one, the people, and two, that we can interact on a global scale in a more safe manner. But one thing I do need to mention is no matter how big or small your business, the POPI Act, once fully enacted, it is partly enacted as we speak, is going to affect you. And the information out there is just so limited, and hopefully you glean a lot of a lot more information to be able to take a different direction from today. It's also, stats say that only 30% of South African business has a basic understanding of POPI. So, these are the stats, just so you know. Those guys in hospitality, 12% accounts for 12% of global breaches coming from hotels or hospitality. That's a big number. If you take out of 100% globally, 12% are coming from hospitality. Number of records stolen in 2016 was 9.6 million, but that changes. I've just added a little bit there. In 2018, Marriott compromised 500 million people. They bought another business that bought into the Marriott portfolio. They had already hacked them in 2014 and were in their reservation system and in their loyalty program system. Their passport numbers, their social security numbers, it was unbelievable. It was the biggest breach known in history. Happened November last year. Well, it came out November last year. And guess what? When did GDPR come into effect? In May last year. So Marriott, we'll go through in a second, is liable for a $915 million fine because it's 4% of their global turnover, which is about $21 billion at this stage. But it's not going to go further than that because there's going to be people suing them and compensation for changing their passports and so forth. So they reckon the cost to Marriott is going to be $3.5 billion, which is 35 million rand. That then begs the question, how does POPI affect an American company when it's an EU regulation? Well, GDPR is an extraterritorial law, which means it supersedes any other country's local law. And they can impose that fine on companies outside of their jurisdiction. That's why it's been brought about, because Europeans do business all over the world. They don't want their information breached. Real estate, there's a lot of you here, thank you for attending. 30% of real estate firms reported an information security event in 2017. And this is the kicker, because when we talk about data, data is not only electronic movement of data. Data is paper data, contracts, invoices, HR records written on paper. That is paper data. So 53% of that industry's identity theft was non-digital. So more than half didn't come from cyber crime and attacking the system and the databases. It came from negligence within to breach people's data because of what they've got sitting around in their offices and the systems that manage them. Just a quick one on education. 11% of all breaches affected the education sector, 15 million records stolen. Remember, kids write exams, they've got their different information with a guidance counselor, there's application forms, there's all these different bits of information. Getting people's information before they turn legal age to do identity fraud is going to be huge. And South Africa is, as you saw, the third worst for cyber type attacks. And obviously we don't have a law that's fully now saying you have to put measures in place, and that's hopefully what you'll take from today. What can you go away and do? Lawyers are actually very bad at information. They are actually one of the worst breaches worldwide in terms of how they handle the information they have of, cases and so forth and so forth. They move it around a lot between courts. Think about it, it's a problem. So 35% of surveyed law firms, this is in the States, admitted they had some time of information breached. 38% of law firms breached reported a loss in billable hours. 34% incurred hefty fees for correction, and 23% reported costs associated with the replacement of office hardware software. So what is deemed PI under the Act? And this comes from Mickelson Law Firm. They're on the internet a lot. They do a lot of blogging on the subject. They're all over the place, so I'm going to use them as my reference.
Can I comment?
Sure.
They actually are final regulations.
Oh, they're final regulations.
Drafts were issued in September 2017. Public comment was invited on those, and that public comment was combined and published and gazetted in December 2018. They cannot commence until the Act commences, but they are final regulations.
Okay, then there's the Protection of the State Bill, Information Bill, and the Cyber Crimes Bill. You know, in Europe there's a cookies law. It's called the cookies law, which is the cookies on your websites, which we'll talk just now. So those are the 5 things that now define personal information. So let's give you an example. Okay, this is A2. Information relating to race, gender, sex, pregnant. If you're pregnant or not, it's deemed PI. marital status, national, ethnic or social origin, color, sexual orientation, age, physical or mental health, well-being, disability, religion, conscience, belief, culture, language, and birth of the person. Okay, that's just the top line. Any identifying number, symbol, email address, physical address, telephone number, location information, online identifier, or any other particular assignment to a person. The biometric information of a person. I know of a company now that's rolling out biometrics to all of their 600 stores. That's a consideration now. As soon as you're putting those fingerprints onto that machine, that device, that's now covered under PI, and ensuring that it doesn't get breached or lost or damaged, because you've got to keep that for a certain amount of time, and when you destroy it, it has to be done in a proper manner. Correspondence sent by a person that is implicitly or explicitly of a private, confidential nature, or further correspondence that would reveal the contents of the original correspondence. So it's quite, I use the word hectic. Their personal opinions, views, or preferences of the person are all deemed personal or personal information. The views of and opinions of another individual about that person or the person, and the names of the person that appears as if it appears with another information related to a person. It's crazy. So what I want to make a point is, what is data, what is PI under the Act? So automatically think ID number, passport number, bank account, all those really hectic things that can damage you. It's a lot more than that. And so I'll give you an example. I was talking to John this morning, and I'll introduce John in a bit, but he's a super guru expert, and we're very lucky to have him today. But I'll do that in the introduction. So, Company A gives you a quote, 15,000 Rand to do something, okay? They send you an invoice or quote, usually got under the Consumer Protection Act, you've got to have the company registration number, the name, the registered address, the directors at the bottom of these documents now. So it says 15 grand plus VAT, and you say, oh, I need to get another quote. At the moment, what we do is say to the guy, I've been quoted 14. And he's like, okay, send me the invoice. Oh no, it was 15, but can you do better? And you obviously send him the invoice. We say, send me the invoice or the quote so you can prove that that's the amount, then they give you a better deal. You're not going to be able to do that, because that was intended to you from a company with all their details on it, their banking details, their company registration number, their location, their prices, and maybe some proprietary information about the products. You won't be able to send that email without consent. Do you think they're going to consent that you send it to the competitor? So things like that is going to be breach of POPI. There's so much more to this. I mean, we could stand here and speak to you for days. I would hate to, because you'd all be fast asleep. But it is really going to be that. No, it goes as far as writing. You're sitting across someone, you write their phone number on a post-it note, because your phone's not around, and you leave that lying there. They're not going to put you in jail for that, but that is how far it goes. You write down the number. What we typically do, you take the post-it note, put it into your iPhone or Android phone. That's behind fingerprint or facial recognition software, so you can only get into it with that. You type the name and number and you save it. That's now protected. You've taken reasonable steps to protect that number because it's on your phone behind password control or facial recognition control. So the reason I'm saying terminology questions at the beginning is, what is a risk assessment? And I think you all know what a risk assessment is in terms of health and safety and other parts of your business that you look at risk. But under the POPI Act, what the information regulator is going to look for is, where is your risk assessment? Show me what you've done to assess your risk in your business. And that's PR and marketing, HR, finance, operations, everything that builds the individual components of a business that a general manager or a business owner or an MD or CEO would oversee. It's every component. Even when you sign in at security, and security takes a scan of your license disc and takes a scan of your driver's license, they have been contracted for that property. You have responsibility over that information because they contracted you. They are provided, service provider. You've got to go. That's going to be your responsibility. So, risk assessment, and we actually use the word risk assessment in the Act. Question is, and then the other thing is, what is a privacy risk assessment? There's another thing you've got to do, a privacy risk assessment in your business. And then I say, how do you do a risk assessment if I don't know what I don't know? And that's where we are talking today about taking you on that journey, giving you all the tools to be able to do a full risk assessment in your business. And if you started today, it's going to take you a year. When the President signs this act into final enactment, you're given a year's grace period. A year with the amount of work that needs to be done, it will go so fast. When you're looking for a supplier that are all going to jump out of the woodwork with zero experience and think they can jump on the POPI bandwagon, you don't know what you're getting. And that's why we're here to build a relationship with you. You get to know us and see what we're about and what we can do for you, so that when you come to that decision, you know that you're working with someone that's willing to walk the path with you and not just take your money. That was the backup, but my site is up and running again. I had such a fright, even though we've done everything to protect it. If you don't have that HTTPS, the S at the end is the HTTP for security, you have an unsafe website. And if you're running cookies on your website, that is a big threat. Also, it's easy to take down that site from a hacking point of view. It's easy to, especially if you've got forms or you've got online booking or e-commerce, it's a very big problem. I don't think any of the e-commerce guys here have an issue. Just as a generalist or a general manager or an owner, you need to be aware of these things, because that's something that could take you down. If your website's down, what do you think the customer's going to say? Oh, there's a privacy issue here, I'm not going to touch them. It's a bit of a concern for me. It's an image thing as well. Okay, so some key overview from some of those questions. So really key things to take out is the information officer. Who's the right person? What are the explicit responsibilities? Now we've put a page on your table there, the responsibilities of an IO, information officer. I'm not going to, that's for you to go through. It's just a courtesy to give you a bit more information, because it can't be the new admin girl that doesn't have a lot of things to do, or the receptionist, or the PA, or the actual IO responsibility is the CEO, that level, but they can delegate that responsibility, but they can't delegate. It'll be general manager then. So the IO, the information officer, is actually where the buck stops, really. They can delegate, and that delegation go to a senior person who then can have a deputy. So I'm just saying that who is the right person? Is the IT person the right person? Because they see IT and they don't see the HR, the finance and all that, or because they don't understand those departments. So a generalist who understands the business and knows where to pull the right team for that scope project budget together, to put the right team together to delegate, not delegate the IO responsibilities, but the project work that needs to be done. So that's the project budget scope. So it's the stakeholder buy-in is really important if you aren't the decision maker today about what you do going forward, as the consequential fall guys and girls are for not having authorized a risk and privacy impact assessment undertaking. They're the ones that are going to be sitting in front of the courts being judged as to whether they're going to be fined and or imprisoned, because we know it's up to 10 years. So getting the buy-in from your stakeholders for that project scope is absolutely important. You've got to agree on the project, the budget, who's involved, who's the person that's going to be leading that project from a project management perspective, the information officer. That's something you have to take away today and say, how are we taking this forward? That's the first point. And then policies governing all departments, departmental security, notwithstanding things like CCTV falls under POPI, biometrics. I'm just saying, other than your normal departments you normally think of, you've got your security company, you've got who manages CCTV. Those are all now filming people. If there's audio, that's all PI. So don't forget about those things that are now new to our understanding. Security companies, IT, HR, finance. So it's how the whole departments feed into deliver the privacy impact assessment and the risk assessment. And then training. We all know, we all pay towards the development levy. Use that money to train your guys in POPI. It's going to be there, it's not going away. We have quite a fantastic online system, which means you don't have to lose staff to venues like this for face-to-face training, unless you prefer it. There are companies that prefer face-to-face, but we have a fantastic online package which John will talk to you about, where they can do it from the comfort of their desks. So the question is, what reasonable steps have you taken? And can you show that you have identified with the risk assessment and privacy impact assessment, showing proof that mitigating steps were taken? That was what the regulator will look at. You can see that you've taken all the necessary steps, you're working on it, it's a constant plan, you've got a risk assessment, you're working through it. That's all I think one can ask. It's being reasonable. But if you haven't and you think, I don't know the South African Act, I'm not really a fan of those, we're not going to do anything, that's where you're going to really be, your business will be damaged financially and reputationally when you get thrown across the press about not abiding by the privacy laws, which protects us individually. Okay, so over the past few weeks, the internet news feeds have been abuzz. Notices from all quarters have reached you regarding GDPR. So we spoke about that. What is GDPR? The General Data Protection Regulation. Don't you love IT? Is the European privacy law which became enforceable on the 25th of May 2018. It aims to strengthen the security and protection of personal data in the EU. The law determines how companies must process, protect, and notify their customers about their personal data. This includes all aspects of collecting, storing, transferring, or using personal data. It includes anyone living in the European Union. Why is the European law important to South African businesses? Global trade has resulted in cross-continental data exchange. The manner in which data is collected, processed, stored, and transferred has serious implications for the privacy and security of individuals. If you have an online business, you can have customers in multiple countries, including the EU. This legislation affects you as it has been designed to protect your customers. So the question is, I have a small business, does this really affect my business? The answer is a resounding yes. If you collect and process your customer data, then you need to be GDPR and POPI compliant. Imagine you own a small guest house and you have an online booking system. Your guests from all over the world, including the UK and Europe, are able to book accommodation at your guest house online. In terms of GDPR, you are a data controller. Your online process requires collection of their personal data upfront: name, address, email, phone number, passport, ID, credit card details, etc., captured on your online booking form and stored on your server. Therefore, you need to be GDPR POPI compliant. If your online booking is processed through a third party or data processor, such as bookings.com or tripadvisor.co.za, meaning that they collect the personal data on your behalf and then pass it on to you, then they and you need to be compliant. Is Hetson the GDPR compliant? They say in short, yes. How do POPI, POPIA, and GDPR relate to each other? Well, basically, POPI is fine and jail time, and it's business and individual. GDPR is only individual. It's got nothing to do with business transactions. So and then obviously POPI, there's a fine of 20 million euros is the minimum fine, which is about 300 million rand, and then or 4% of global turnover. So in Marriott's case, the global turnover is $22 billion. Their fine at 4% was $915 million. And with the other penalties they believe are coming, that's they reckon $3.5 billion, which is 40 billion rand. And that's real, that's happening. That's what's going to end up happening. It's stories all over the place about it. I've got some information on for you as we speak. I want to talk about this little picture here. This is like called a router, and I'm sure those who aren't in IT have probably seen it lying around the office, something similar. That's obviously an easy way into tech. IT, hopefully, some businesses don't have a dedicated IT, but upgrading the firmware, changing the original passwords, there's silly things you can do, but this is like an easy way in. You must actually look at HP, the Wolf. It's Christian Slater in a series of 4 videos. I'm not going to show you, it's quite cool, but it takes too much time, about how people can access into a network from the printer, which hasn't been secured. But anyway, I don't know if you see this very well, but this is basically like what a database would look like behind the scenes. And this is your PCI, your payment credit information. So some of you have separate credit card machines, some of you have integrated with your PMS and your ERP, your enterprise resource planning. It all interconnects, and it's all very smart and clever and efficient. So in the States, PCI, you now need to be audited and cleared in order to have it. South Africa, not so much yet, but that's another way. This is what they're after. They're after that payment credit card information. So I know Anchor Data, for example, and I'm sure you have all different.
Can I come in just for a second?
Yeah.
So PCI stands for Payment Card Industry,
Yeah.
and it's driven by Visa, MasterCard, and really is a standard for demonstrating that you protect cardholder information. So it's not a law, but it's a standard. And if there is a violation, a breach, and that standard and that body is empowered to fine organisations, and that's certainly happened. It's certainly applicable to South African organisations.
MFP, multifunctional printer. When you do your round robin of making decisions to renew, because what happens is most companies, unless you've got lots and lots and lots of money, you just buy these cash all the time, will lease these. And most of these have a hard drive. And everything you scan gets stored on a hard drive. And guess what? When you get a new machine 3 years or 5 years later, it goes into the second-hand market, and someone else sits with your machine with all your information on it. Okay, so make sure it doesn't sit with the hard drive. Also, you've got those big A3 machines, then you're going to have hard drives, and you need to then have extra protection of getting in through this way, and also making sure that your network security is, or on those big machines, they have to have hard drives. They're dealing with high volume. This one doesn't. And the reason we put this scanner next door is because we want to, as a business, from a POPI perspective, and moving into the future and into the 21st and 22nd century, is move to not an electronic document management system, because those are very expensive. They usually charge per user 300, 400, 500 rand per user to have the full document management system. I say learn to do it yourself. Scanner, back scan your documents. Nice thing about scanner, it does not have a hard drive, and it's designed for scanning. This works perfectly fine, but it's not high volume scanning, like 60 pages per minute. And you can't resize it, crisp it up, redact, do all sorts of other functions with the OCR technology that picks up the wording, tag it, and when you search for a scanned document from a scanner, it's much quicker. PDF, you've got to right-click, save, name it, and then you've got to remember which folder you put it into, and when you're looking for it, often you can't find it because it's been embedded. So it's something to think of. And we'll talk about this just now, but we call this like your printing, scanning, and destruction bureau. Okay, it sort of acts as a credenza. We'll chat about that in a bit. But I just wanted to point out scanning versus MMPs with hard drives, and the back end into those items. Other basics. Talked about my site losing the S on the end of the HTTPS last night, freaking out, saying my website was at risk. That got sorted very quickly this morning when they opened. Do you know the difference? So there are people in this room that, I don't know if actually there are, because I just know that from checking the list there are, but whether they're here is another story. Don't have even the basic of having encrypted website encryption, which is your SSL certificate. Just a basic. Most of you got it. It's something to check. And I didn't realize mine wasn't reoccurring every year to pay. They just shut me down, and then I had to find out this morning what I had to do. Under GDPR, any companies doing business with EU citizens need to have the cookie policy, or in the EU it's called the cookie law, where you have to have that warning. Everyone got that warning popping up on the website? Well, we've all done it, but we don't actually have to, because it's part of, I'm doing business with the EU, don't have to, but I suppose it's just good practice to do it. But you're already starting to comply and not knowing why, because everyone else is doing it. But like the email signature, all do it, it's my email disclaimer, and the cookies notice. Okay, so just so we're not trying to name and shame anyone, this is just fact, this is what happened. In the real estate industry, there was, it first said 60 million bits of personal information was breached through a holding company that owned various real estate agencies, okay? This happened last year, but the scary thing, this wasn't even a hack. This was information they got, and how they got that from the deeds office, I believe, to help find clients. It was almost like open source. They didn't even have to hack it, it was there. And they got, in the end, they found that 31 million South African ID numbers, email addresses were breached. This was a little while ago, I think last year or the year before. There you go. Private reports of 31.6 million South Africans removed from the internet without even having to hack. It was just there. Now your information is still sitting out there. It could be, I might not be in the I might be in the 20 million that won't. but I'm just in the process of buying and selling and so forth, you know, and I would be in that transaction of information, and now all my details would be out there. It is out there.
We in the real estate, obviously, so we got something that's called CMA, and that we do property search and stuff, but the owner's details and ID numbers and all of the others on. So with the CMA, the program itself, would that then be needing to be compliant as well, I suppose, huh?
Yes.
They are, because that is then the third party.
But I got called by an estate agent last week for a house that's not on the market, asking if I want to sell it, with my phone number.
It happens all the time.
I
So,
think,
why are they allowed to do it?
well, they're not.
So,
Give them the wrong phone.
And the point about the Act is why the Act is actually being brought in is to begin to regulate and control. That is a wild question. Our privacy is being abused, as the question shows. It'll take time. We'll need to see examples made, case law, and it's going to be a journey. The bottom line is our privacy is being abused.
POPI stipulates that you may only keep PI, personal information, for as long as it is required. What is your procedure for destruction of information? So that's your retention documents. You've got to keep that in the storeroom or those Metrofile boxes. Those you can't over-retain, you can't under-retain. If you lose that information or it gets damaged or you lose it electronically or physical, you're actually in breach as well, because you've got to be able to provide that to SARS, or if they come and ask, it needs to be there. Likewise, you're not allowed to over-retain. So 5 years and 1 day is technically in breach. You need to have a rotation system and a system that works in order for you to make sure that those items get destroyed properly. So what procedure? Get a third-party company to do your destruction, to make sure that it's destroyed, certificate of destructions are provided, it's all kosher, and you do it. A lot of people have shredders, but what is your security level on that shredder? Shredders break down, and I know that most companies supplying shredders, although we do, it's 2 years of guarantee on parts, and then they don't carry the parts anymore. So even if your machine just needs something changed and they don't have the part, they say buy a new one, and they're flipping expensive. So we talked about that, sorry, we'll skip that. And then, what are you doing? Are your document archives looking like? So, are they 7 years, 8 years? Get them back to within their retention and get a service to come and collect it, destroy it, give you a certificate, and it all goes into, by the way, all paper written on with pen or typed on goes into the one-ply toilet market. That's my background. I work for Nampak Tissue, and all paper, where we're not cutting down a tree, it's called secondary fibre. That paper there, now if you throw it in the bin, when you get back to your office, is going to, or actually not in your bin, it's going to recycling bin at the stage, goes into making one-ply toilet paper. And later we're going to give you an official government gazetted form, which is on the Justice Department's website under the Information Regulator, which is the format in which you're going to have to go forward for direct marketing. But don't let me forget to give you that, because it took me ages to personally staple that. And that you can go into your information technology and create that same form. That's the opt-in form. It's an interesting one, and actually the direct marketing industry has been lobbying the regulator and the advocates and the attorneys involved in the drafting of this regulation to please tone it down. And John, they did tone it down a bit, man. It was so hectic, it was going to destroy your ability to market your business. So now they've actually toned it down quite a bit. So where we're at, and John said it is the final regulation that has to be signed, even though it says final draft, it is the final regulation. We'll give that to you. I do have it somewhere. It's 2 pages, and that will be the format in which you have to send out to get people to opt in. They sign to say that I will receive, and they indicate if it's email, telephone, fax, and if they say just telephone, then you've got to note that in your information capture. Okay, so just very quickly, I want to skip through this very quickly, because it's just examples. You and your respective industries know this very well. But when you buy a house, everyone's probably bought a house or rented a property in this room, otherwise I'm not quite sure where you're living. I've just gone through the process of selling a home, and it just reminded me as to how incredible amount of information that's required in order to go through that process. But let's just look at, it starts off with the offer to purchase, and I know on that document it's It's got my SARS tax number, ID number, bank account, where I work, all sorts of information, signed by buyer and seller. And then that information sits in hard copy at the agency. It gets then emailed to the transfer attorney, cancellation attorney, the bank, and it just goes on and on and on and on. And then from the purchaser side, I mean, if you've got in-house bond originators as part of your business, they're then looking for the best interest rate before it goes to the bank. And there's so many people, this information moves around just on that one document. What I find quite shocking is that my business is going to take me to Johannesburg a lot more often. I'm spending sort of 5, 6, 2, 3, 4 days at a time in Johannesburg every second week. So I'm going to be renting in Cape Town and renting in Johannesburg, like a service apartment, so I can have a place in both, because I'm spending so much time in both cities. So I'm just going through the rental process, and that, I mean, you won't be able to see. Why this went? Let's see if it does. There we go. So, tenant application I filled out was 5 pages. Credit checks and reference checks, private correspondence, because that's the correspondence between me and the agent, emails back and forth containing PI. After the pre-qualification of getting a rental, so it's an enormous amount of information. We had ID document, certified, bank statements, payslips, proof of current address, cell number, email address, children's name and ID number are going to be residing at the rental property. Criminal record, they obviously check, and I just put there the pet, the breed, the size, and the photo of my pet. I know it's not personal information, but wow, I know that's where it's going. It's fortunately my dog's not covered under PI, but she had to have a picture taken, measurements taken, and information put on the application. And I've said there, what happens to all this pre-qualifying personal information once rental agreement is signed? Because this is all to get to a point where they say, you're approved in terms of your credit rating, affordability, and the landlord is happy to take you as a tenant. Approved. And I know some of that has to be kept for FICA, but it's how you now handle that information and protect it and store it, and who has access to it. And that's the type of things you're going to be thinking about. Where we said at the beginning and on the invitation, how disruptive this is. It's going to change the way you do your business, because the way it's being done now is not going to be correct. The scary thing is what happens if your application is unsuccessful. I know agents are now like, you've got to pay when you send your application, you pay a fee. So there might be 10 people going for the property, so they're going to make 9 people's money on the application, and one's going to be successful, but there might be 9 people that are unsuccessful or preferenced by the landlord. That's 9 sets of those documents for a person you're never going to deal with again, or not now, right now. And even if they deal with you again, then the certified ID might have expired against your policy within 3 months, and you need to get it again. So you might have it 2, 3, 4, 5 times over different properties if it's a gap in time. So I just want you to think about that. The rental scares me more than the selling of my house. Because again, it does go to a lot of lawyers, and I did have my comments about the breaching history with paper, and they're also jumping on the bandwagon to do POPI. Lawyers wanted to tell you how to do POPI when they themselves are actually in the top 5 of the international breaches. So hotels. This is interesting very quickly. I don't know if I'm going to be able to, let's see if it does. So PwC, is the lady from PwC here? There was someone that was going to, oh hello. Welcome, big respect, senior manager at PwC, auditing firm. They do a hospitality outlook every year, and it's usually over a 5-year period. So this is 2018 to 2022. There's a 2017 to 2021. But the reason I pulled this up just it's only to show you this, is this is their report. 59% of security leaders say digitization has increased information security spending. Hotels are already in the spotlight due to high-profile breaches. The last 2 years have been particularly bad for the hotel industry, and trends suggest that it is unlikely to get better. widely publicized breaches of reservation and point of sale systems paint a worrying picture. So, and then of that sort of 8 million people a year, how many do you think are from the EU? Actually, funny enough, you're right, it's 2 million. But that's 2 million EU visitors coming with that data protection law on their back that is now in force, staying at your properties. And we know that Cape Town is the first and the highest of those visitors because of our beautiful city. So a lot of them will stay in one of the Cape Town properties. 2 million a year, just EU, and growing. And the property market, according to PwC, in the 2017-2021 and 2018-2022 reports, is very encouraging. It's been slightly adjusted down from the 2017 to 2021, but it's looking very positive despite the challenges that you guys have had with water and other things that are happening in our country. But you've got a great business, and you obviously people want to come and see it. That GDPR thing needs to hang in the back of your mind, because you are liable now. You are under GDPR if you're entertaining and taking European guests from the EU. Okay, so I'm not going to show you this. I've in the last 2 weeks had so many, ironically, for this presentation, I've had so many examples I could show you of potential phishing, but like real simple, easy to spot, like are you kidding? To stuff I've actually had to phone the company and say, did you send me this purchase order because it looks legit? And then I've asked to speak to the person in the mail, and they said this person doesn't work here, and by the way, it's a hacking email. But I've got 20 I could show you that came through in the last 8 to 10 days. And I put it into a hacking folder, which I really need to delete, because if I accidentally click on one of the attachments that I'm not supposed to when showing you this now, might not be a good idea to show you, but that is literally, it's happened in the last 2 weeks, more so than it ever has. Like really basic ones to quite, because obviously I'm looking out for it. Then I was going to show you some emails where our servers blocked them. So they've actually said block malware is indicated, delete. Then other ones that says, would you like to block, hold, or release? So it's basically taken a decision to say, do you want to look at the name? I know that email, I've got emails from them before, but there's something in that's causing our system to say, this is review it. And then every time we go to a new site, we have to put in a authorization code. So we click on, we'd like to release it, they send us authorization code, we put that in, and then it releases it. And every email from that person going forward is typically released because you've approved it as someone that you trust. There are so many different systems out there, but I wanted to talk to you about encryption in, encryption out. I think you need to look at that, and that's something we can also, we've got Elroy here from a company called Cyberwatch, who's been giving me some awesome advice, and I'd like to also introduce him to you through email of someone that can provide these services, because they say that South Africans are using, you've got 1G, 2G, 3G, 4G, now 5G is coming out with all the controversy with the cell phone company in China. They're saying that South African companies are using 2G technology, this is analysis, to fight 5G cyber hacks. So we're way behind. We really are, even a small business, getting the encryption right, encrypting your emails in and out, getting the necessary systems in place now, and just making sure you update them. And obviously, again, talk to us. We've got all the facility, one-stop shop, dealing with one company that can provide you. We've partnered with John will speak to you in a second, 2 Johns actually, where I've selected these companies to partner with me because I trust them and I've vetted them, and they've vetted me, and they're happy for us to give you a combined solution instead of trying to go and outsource all of this from everywhere, wondering what you get. And one point of contact as well, by the way. So encryption, threat protection, firewalls, not just antivirus. If you are going to start digitizing your documents and getting less clutter in your office and less access to the 25% of breaches come from staff because of lack of systems and training, you need to back it up. So you can physically back it up do it by yourself, as long as it's done periodically. Because if you do it every week, then you know that if you lose something, you lose at least a week. If you do it every day, you're not going to do that. Or you can use a company that's within your portfolio of services probably that can do backups for you and they usually back up at more than one place. You've got it on your server, their server, and they've got a backup as well. Because like I said to you earlier, losing information or having it destroyed, deleted, hacked, stolen is as bad as over-retaining it as well, keeping it for too long. Okay, so just remember that. Remember, your IT guy, who are actually the hardest people to convince when it comes to POPI, because they do think they know it all. And no disrespect, because you guys are brilliant, you keep us safe. But you can protect what comes in and you can protect what goes out from an IT perspective, but guess what? You all print.
Yeah.
You push that print button and it prints to a printer
Yep.
all the way down there. Then you get to the printer and you're like, oh, that's supposed to be landscape, not portrait. You walk back, you print it again correctly. By the time you come back to fetch, someone's picked up your documents with their documents they've just printed to the central printer. It's on their desk somewhere, but you forget about it. That's sort of sitting there now. It could be your financial results, it could be your financial, because obviously those are the ones that often print wrong. They're the ones that print off the page or the wrong way and you've got to print them again. And that's when you get to the printer and you put it underneath in a secure shredding box, which will be chain of custody collected and shredded. But anyway, we'll talk about that now.
And now there's the cloud.
Now listen, don't be scared of the cloud. I mean, I'm not an expert at all. I think if it's not in South Africa, it's a problem. I think I said to someone earlier, the only time you have to worry about the cloud being outside of South Africa, which most of them are, is if there's some serious political thing that goes down between, say, where 365's hosted in Ireland and South Africa, and they think, well, let me just cut the line between SA and then all your stuff's hosted is there. I mean, come on, is that gonna, is our president gonna really upset the EU that much that they cut all our lines? And plus, there's all contingencies in place. And then you've got Hetzner that's South African hosted and African hosted, South African hosted, if that's your concern. But the cloud is actually, I haven't heard of many cloud breach stories, John, recently, they're all up the act.
They're fairly good.
Yeah.
They're very good, but they're very good.
More chance of you internally hacking yourself or creating a breach than one of these big, super big companies with the level of protection they have. Third-party suppliers, it's just a note. Remember, if a third-party supplier is doing business with you, you need to, within our tools and our guidance and our consulting, we'll show you how to contract with them properly and make sure that you're protected with your relationship that's there's a contract between you that doesn't limit your liability, but it makes sure you choose a supplier that's willing to walk that journey with you as well and be POPI compliant. I just put it here because it's like a simple thing. I was going to pull up, people tell my people, oh, we are insured for this. Let me tell you something now, there's no such insurance available in South Africa for POPI and GDPR. There is not. So anyone wants to tell me they're insured for this? One, there is cyber insurance. And if I took you through the document today of that, what they want you to comply with in order to be insured, it is more hectic than POPI and GDPR put together. They've covered their bases because they are not paying 1 cent out. You have to be more perfect than perfect in order to even qualify for the insurance. And guess what? It covers you for the fine, doesn't cover your CEO from going to Polesmore. Because you can't insure that. You can only insure the fine parts, and that's whether you've met all these strict conditions that even when I look at the document, I go, how do I answer that? They want to know how many, it's incredible. If we had time, I would have taken you through, because it's almost like a reverse psychology to say, okay, let me get insurance for this. You're going to have to work harder than the rest of your colleagues in the room to become POPI compliant versus that document, to become insured for cyber attack. Because obviously if you cyber attack, you're going to affect other businesses and other people, and you're going to have to pay out money. You want to insure yourself for that. But if you're incredibly sharp on POPI and GDPR, then maybe get the insurance. But if you're so good, you probably don't need to insure. But there is cyber insurance to cover cyber threats, but not POPI and GDPR. We talked about bringing your own devices, big risk. Do you know, like in our office, we have a guest Wi-Fi and then our normal Wi-Fi. And we firewall our guest Wi-Fi on separate IP fixed addresses than we do on a normal, because you shouldn't allow your guests onto your normal Wi-Fi, because that's what your finance guys are using. That's what your internal people are using, and if they have access to the Wi-Fi. So most people have a separation, almost like a wall, a digital wall built between guests, Wi-Fi. Someone comes to your office like, Monica, if I'm playing, you let me into your Wi-Fi and I'm on my device. actually, you shouldn't let me do that. Because now I've got my potential corrupted device on your Wi-Fi. No, I didn't, I used my own the other day, but that's a big thing to think about. I'm sure the big companies out in the room are all over it, but it's worth mentioning to you for your own peace of mind. Okay, so I'm not going to click on this because it doesn't work clearly, but this is the Form 4, Section 6 for direct marketing. So we're going to hand it out to you. Please take it before. It's actually there. There's 150 of them. Just to show you the format of what you've got to do. You've got to send this to either in that format or electronically that's been built like that, where people give you consent to direct market them. You can phone people under POPI when it's in. You can phone them and say, "Hi, can I send you some information about our services?" Yes, of course. That's consent over the phone. You follow up with the document. If they, and also if you email them, if they reply, yes, great. If they reply no, you know what the answer is. And if they don't reply, it must be seen as a no. But look, start this now, don't start it now. Maybe it might be a bit too early because then you are doing everything correctly, but no one else is doing it correctly. So, but just be aware, that's going to be, especially real estate and hospitality, where you rely on, and you've got specific teams doing direct marketing, handling your social media, and all that type of stuff is going to be a huge step change, okay? And we, again, can help you through that process. Hopefully you can read that. It's, I hate a sales pitch, saying our service to become part, medium, and fully compliant ranges from 13 Rand per day to 96 Rand a day. That's less than a tea lady in your business to go on the full POPI journey with us. That's retention and destruction services. That's scanning, teaching how to become electronic data management wise without the hard drive, and the POPI license toolkit. So talk to us separately online about that. And I put it in day terms to make it real. You'd understand that the cost is, and please do comparative. That's for full active services. Obviously what will come out of your risk assessments and your privacy impact assessments may be like, we really don't have certain systems in place and we're going to have to invest in it and we're going to have to put that in our budget for next year. That's good because you're not expected to, you've identified those risks and you've planned to make the necessary investment with whatever it may be and put it into your budget. That's what the regulator wants to see. They can't expect every company just to afford to change everything overnight. There's certain things that are going to pop up that you had no idea about that you're going to have to plan into your future, and that forms part of your plan, and that's what they want to see. Reasonable steps.
Right, good afternoon everyone. Thank you, Colin, for your introduction. Very flattering. I'm just John. We're running behind schedule, and I've taken a section out. The intention was actually to do a quiz. And the purpose of that is really to draw you into the subject in a slightly different way. But in the interest of time, I'm going to skip that, I'm afraid. So really what I'm going to try and cover today is, I think, build on what has been discussed by Colin, by John and Christo already, and try and give you an insight into the way we approach these compliance projects. And that's really what we're going to do. So I have planned to cover a number of key aspects of the Act. They have been covered already. I'm going to flick through a few slides, if I may, and really just touch on a few things that I think are very important. And then we'll go into top 10 tips. In other words, what one should do to prepare for complying with POPI Act and with GDPR. And really, how can we help you? And if there's time, we'll do a little practical exercise, but we'll see how we go. Okay. So, Colin will probably punch me on the nose because of talking about the 8 conditions. So, in the Act is basically made up of a number of conditions, which are principles, and those really are important. But then we'll look at some of the other things, like there are some additional areas. There are just a quick slide on what is personal information, that's been touched on already, and so on and so forth. So, the 8 conditions. The 20-question quiz or the assessment, the high-level health check we did, was based really on these 8 conditions, these 8 principles. And it can almost be summarized by saying there are 2 things that are guiding principles when implementing compliance, protection of personal information compliance processes. And they boil down to purpose and consent. So we shouldn't be collecting information, processing personal information if we're not doing it for a purpose, and if we are not doing it with the person's consent. So if you don't remember anything else about my talk, please remember that. They're already key. And these opt-ins, the opt-outs, all these things, they're very much about obtaining and keeping records of consent, hugely important. Because in a court of law, if there's a breach, one of the first questions is going to be, did you have consent from the person to process this personal information? And if you don't have records of consent, you are going to be on the back foot. Okay. There are a number of extra areas, and Colin's already touched on special personal information of children, and so on, and we'll touch on those a little bit more as we go. So, at a very high level, that's what personal information is about. The big blobs are really the general personal information. We touched on it earlier on. Colin asked the question, what do you think personal information is? And I think answers were things like name, address, ID number, photo. And that is true. And so these are general personal information items. But we do have a category of special personal information, things that we need to actually regard as being more sensitive. And those are things like religion, health information, biometrics, and so on. So please bear that in mind. And then, as Colin said as well, personal information of under 18 is important. The Act really says that we may not collect that personal information unless it has the consent of the parent or legal guardian. So we do quite a lot of work with schools. Clearly that's very important for them. So that's a quick snapshot of what personal information is. There's 3 key parties we need to think about as well. So Colin touched very briefly on what these are. So the first one is really the data subject, that's you or I, and very importantly what Colin said is company information. And POPI has taken in the notion of a juristic person. Now, a juristic person is something that is contained in the Companies Act. And the POPI Act, our lawmakers decided that personal information isn't only about a living individual, it's also about a juristic entity or a company. So when we comply, when we prepare for complying with this Act, we need to worry about both. That is not the case with GDPR, so it's something that we have to actually manage from a risk perspective ourselves. Okay. Responsible party is fundamentally your company. So you're entrusted with personal information of your customers, your staff, trading partners, so you have a responsibility as the responsible party for protecting that personal information. That is called a controller in GDPR terms, but it is the same party. The operator is the external service provider. So if you use an external service provider to process personal information as part of a service that you provide, and typically that'll be in the hotel industry, it may be a travel start, maybe a booking.com, maybe in a more conventional note, it may well be an IT hosting company, an HR hosting company. That is an external operator. And we need to make sure that we've got safeguards in place to protect ourselves in that regard, where that personal information that we are entrusted to, that we are responsible for, is actually being processed by an extra company. Okay. Then, internal roles. The key role. So one of the first question in the health check that we did much earlier today was, do you have an information officer appointed? And that really is the starting point for the Act, preparing for compliance. So the Act says that by default that is the designated head of the organisation. And that means the CEO, the managing director, and a government department would be a director general, and so on. And the formal appointment of that person is key. and we'll see why in a little while. But realistically, a person in that position has not got the capacity, just can't do realistically the work that needs to be done. So the Act makes provision for a Deputy Information Officer or if officers to be appointed. That appointment needs to be done formally. So, we've given you a freebie today. In front of you is actually an Information Officer appointment letter, which covers the responsibilities of that role, that key role. The Information Officer role is required by both the POPI Act and the PIA Act. So Colin mentioned PIA, the Promotion of Access to Information Act, earlier on. You'll find the requirement for an Information Officer in that piece of legislation as well. So on the single sheet, the appointment letter that we've provided, you find the responsibilities for the Information Officer for both POPI and PIA. At the bottom of the page, you'll see the acceptance of the role of the Information Officer, but you also see below that the acceptance of the responsibility as the Deputy Information Officer. And we really recommend that when you start this process, this is the starting point. Why is that? Because if we look at the Information Officer responsibilities contained in the regulations, the POPI final regulations that were published in December last year, the starting point is to say that the Information Officer must develop, implement, monitor and maintain a compliance framework. So what is a compliance framework? Well, we've heard a lot of things today about, and Colin's given you a lot of ideas in terms of touch points, places where there are risks, things that we need to do. A framework is actually something that is holistically engineered to cover all these things, all the risks that relate to those things. The rest of the Information Officer responsibilities in the regulations really cover, firstly, personal information impact assessment. And what that means is that if we're going to start anything new, it's quite difficult to retrofit. But in particular, if we're starting a new project, a new business initiative, we need to ask ourselves, is there an impact in terms of privacy on this initiative? What does it mean from a personal information protection perspective? And that's really what a privacy impact assessment is about. Because it's part of our risk assessment. It tells us what risks we need to manage. Okay. The rest of these few points are very much around making your PIA manual available, handling data subject requests. Part of the purpose of a PIA manual is to make available a process or a procedure for anybody outside your company to request information from you. It doesn't mean you have to give it to them, but it gives them an opportunity to formally do that. And that's really an additional role that the Information Officer or the Deputy Information Officer has to fulfill. Okay. The other point here is really about internal awareness sessions, and it's really about making sure that your staff are trained, not just once up front, but on an ongoing basis. So, the point I'm trying to make is when you start your privacy or POPI Act compliance preparation initiative, starting point is make sure you get the Information Officer, make sure you get a deputy appointed if you need to, if your company is large enough to be able to do that. Key, absolutely key. Okay. And really, I think just to underpin what I've said there is, if you look at the management responsibilities for POPI Act and complying, doing risk assessments, there's a very good reason for it. Because in section 109(3)(g) of the Act, it states that fines will be higher where there is no evidence of risk assessments being completed, and there's no evidence of policies, procedures and practices having been put into place which show that you mitigate those risks in an operational sense. So it's hugely important. So management really has to support risk assessments, personal information risk assessments, and the development, deployment of good policies, procedures and practices. And really these things should be approved by very senior people. Okay. And just to perhaps reiterate what was in the regulations, to just make sure people are trained, not in just the structure of the Act, but in the policies that you have put into place. Make sure that these things are maintained. Do things like clean desk inspections, monitor staff behaviour, to see what people are doing and so on. Okay. Any questions? I'm not going to phone a friend, just to see what the time is.
We need to do jumping jacks or something.
Okay. So what are the impact areas? So we've talked about a lot of things. What I've tried to do here is put a few things together which say these are the things that you can expect to be impacted on in your business. And we'll look at some of them in a little bit more detail. So things like the acquisition and disposition of personal information. We've talked about the disposal part of things quite a lot today, and that really is key focus of Colin's business, destroying personal information in a controlled manner. So what Colin's been talking about is pretty much the paper-based, and I really fully support what he's doing. But we also need to remember that there's the digital side of things. So when we delete a file off a computer, it's actually not gone. And John and Christo will certainly endorse what I say and back that up. So what you need to do when you are destroying personal information, you also need to use technologies or external services to make sure that that information is gone as securely as would it be if you use common service or if paper-based documentation is really properly destroyed. Okay. We've talked about the information officer appointment. There will be such things as audits. We talked briefly about consent records because those things will be hugely important. Equally important, denial records. Actually needing where people have said, no, we don't want to give you consent. So if we look at it from a marketing perspective and we say, well, we actually don't want to receive anything from you anymore, you actually want to keep those denial records because you should not be talking to those people again. Okay. And so on and so forth. Remember, information about your creditors and debtors and suppliers essentially, because of POPI, including juristic people, important that to be aware that that is going to be an impact area. Things like emails, document retention, we've talked about, so on and so forth.
Sorry, can you just elaborate on the media and PR aspect?
Yes, certainly. Look, I think one's got to, when you publish personal information, it goes back right to the 8 conditions we talked about purpose and consent. So, before you publish anything that really gives out a person's personal information or enough that enables them to be identified in a way that could be harmful, you actually need to get their consent before you do that. So be aware of the consent and the purpose. If you don't have that, you shouldn't really be publishing any personal information in an article.
So how does that apply in terms of images, taking photos of your staff, and then including that in a press release, for example?
All right, so I think my question would be, will you be naming them?
Yes.
All right, so who are the target audience for that?
It's the media.
Okay. So look, what I would do and what we recommend is when you start a POPI project, actually have a staff consent form which obtains consent from your staff if you're going to do that regularly. And fundamentally it says that your company, whatever it's called, will during the course of business need to collect and share personal information with whatever, and you don't have to name the organisations, but say for a purpose such as you have outlined, and other things like you have to do things like you've got to inform SARS about the personal information they have, their tax payments, medical aid companies and so on. Get consent, get written consent, keep a form. Okay? And that is your record of consent should there ever be a dispute. Okay? Okay. Does that answer your question? Okay. All right. Key impact areas, a little bit more detail. So we talked about the three parties earlier on, and in particular the responsible party and the operator are key. So if we use a service provider that involves the processing of personal information, the Act actually asks for a written agreement to be put into place between the parties in which the operator, the service provider, commits to protecting personal information in line with the law. So that's normally a significant piece of work that we go through in a project of this nature. And the law asks for it. And there's actually in the security safeguard section in the Act, so be aware of that. But that is really your legal recourse in the end as well. Okay. Similarly, sharing agreements, organisations with whom you share personal information but are not necessarily a service provider, agreements of that nature will also be needed. Policies and notices, we talked about privacy policies, we'll need things like information security policies, retention policies, and so on. Okay. Personal information inventories. We need to know where personal information is, what systems is it in, what filing systems, paper-based filing systems is it in. You'll be surprised, a lot of organisations don't know where it is. So the significant amount of work needs to be done to actually do that, find out where it is, who's got access to it, because if anybody asks you where their personal information is, or ask you to see it, you surely need to know where it is so that you can do that. Okay. And personal information processing processes will need to change. So where you collect personal information, you'll need to have consent in a form, or if it's an online form, you will need to have a place in your form which says, by submitting my personal information, I provide my consent. Opt-in is also part of that. So all these processes you need to be very aware of and take action on, because they will impact your business. Right, and then in general, just expanding on that, all the processes that involve personal information processing, collection, exchanging, disposal. You need to pay attention to those. Similarly, don't forget your staff personal information. We talked about getting consent from staff as well. But clearly when people leave, you also need to follow the rule which says don't keep personal information for longer than you need it. But the labour law is actually going to put an obligation on you to keep it for a certain length of time. But you need to look at that. Physical access. So a lot of our organisations use external security companies. Make sure that you actually have agreements in place with them, because that's important. Use of CCTV, photographs, again, you need a CCTV policy, because you may well be collecting personal information of people and sharing it, and the law actually regards that as being personal information. Websites we've touched on, so things like privacy policies, biomanual, cookies and so on. We need to look at those and see how good they are. Okay. Slight repeat here. The point I wanted to make here is that this written agreement, the security safeguard section in the Act says there must be a responsible party to operate an agreement in place with service providers. Colin talked about the transporter flows, very important, so we need to look at if we are going to use a service or send personal information to another country, we need to make very sure that, firstly, that the law is substantially similar to POPI. Otherwise, we need to look at another mechanism, like a binding agreement, to try and get some reassurance, some legal commitment that the recipient, service provider in another country is going to indeed protect that personal information. Okay. We don't really need to tell you what GDPR is about. Colin's covered that. But remember, it applies to foreign organisations who process the personal information of EU residents. So the word resident is very important. It doesn't mean that if a company here processes personal information of people who reside in South Africa but have an EU passport, but their normal place of residence is here, that we have to worry about it. We don't. But where a person is in the EU, so a tourist or someone you're targeting to try and attract to come to South Africa, to your venue, to your lodge, whatever, that surely does actually place an obligation on you. Okay. Skip that. Yeah, so I think the important thing is, does your organisation offer goods and services to EU residents? An interesting thing is it says whether they're free or paid for. If you interest anyone in the EU in service or product from here, you actually need to say, well, we actually need to take this thing seriously. Organisations that run websites, if you monitor the behaviour of EU residents via cookies, certainly. And if you process that personal information, you have to. Okay. Similarities between POPI and GDPR. There's a lot of similarity, and the work that you have to do to comply for one is pretty much the same as the other, but there are some differences. Similarities are, yes, they're both based on conditions, principles, both have regulators, they both have this role of a data protection officer or an information officer. Both have a thing which says if we have a breach, we have to notify the regulator. Both have penalties. Both have codes of conduct. So a code of conduct is something an industry body for an organisation such as FEDASA can put into place, register with the regulator, say this is how our industry will be treating, handling, processing personal information. The differences are quite a lot of it is terminology. We used some examples there already. Penalties, Colin talked about. Penalty for a POPI breach is a maximum of 10 million rand or 10 years jail time for the information officer. GDPR is up to 4% of global turnover. GDPR doesn't have juristic entities, and effective date of POPI is not really known yet. We think it'll happen this year. I've asked the chairperson of the regulator for a formal update during the last 2 weeks. And we are still awaiting for that, but we believe it'll be in the next few months. Okay. Right, top 10 tips. How are we doing for time?
Can I just ask?
Yes, absolutely.
When you talk about EU GDPR,
Yes.
does that exclude the USA and the UK?
It doesn't include the UK. It doesn't exclude the UK. The US, yes, it does, because the United States doesn't have a national privacy law like the POPI Act or like the GDPR. So, because of this...
Service providers in the UK and...
Okay, so the UK... So let's go back and stay on the US for the moment. One has to look at the contracts of that service provider and the privacy law in that country, perhaps. Good news is a lot of them will operate internationally because of GDPR, have put measures in place. So their contracts, their terms and conditions are actually pretty good in terms of their commitments as an operator. Okay, but you do have to inspect them, you do have to be careful about them. The UK, even after Brexit, they have committed to continuing their compliance and support for it. So they have their own Data Protection Act, which is actually where this whole privacy regulation started, even before the predecessor to GDPR came in 1995. The UK had a Data Protection Act. So they are huge leaders in this space, probably the most mature in the world. Okay, does that answer your question? Okay. Right, so how do we recommend you go about getting to a good state of compliance? So we have a 4-stage project methodology that we recommend. And it's fundamentally about initiating a project, assessing where you are against the law, assessing your risks, so on. And for a large organisation, it can be up to 20 different types of assessment. Smaller organisations, half a dozen or so. Okay. But then we need to actually pull those things together and consider what's really appropriate. Now, what the Act says, and specifically in the security safeguard section, says the responsible party, in other words your organisation, must implement appropriate and reasonable technical and organisational measures. So it's not prescriptive. It's not saying that what a small organisation does has to be the same as what a corporate, what a bank, what an insurance company does. It says, do what's appropriate and reasonable, but you have to demonstrate what that is and why you've done what you have put into place. Okay. So we consider that in that phase, and then translating is implementing all the things we've learned in the assessment phase and what we've decided is appropriate and reasonable. Ladies and gents, we should have finished at this time. Are you okay to go for another 20 minutes, half an hour? Are you? No. 5 minutes?
Yeah.
Yes, please do. And we apologise for running behind schedule. Okay, so the first step is really to define and obtain approval for your project, scope your project, make it formal. Appoint your information officer, absolutely key. Perform your gap analysis. Make sure you have a good set of comprehensive assessments done. Analyze what personal information you have and consider those. Implement those things that you've decided to do as a result of your assessments. Review your websites, update your POPI manual. Incidentally, there are updates, there are changes needed. POPI manual has been around, the Human Rights Commission actually administers it, and what is actually in their guideline, their template, is actually lacking some of the requirements for POPI. We can help you to publish and maintain and update the correctly compliant manual. Implement the changes you need to in terms of your collection, your personal information collection, management, destruction processes, and make sure your people are trained, because this thing isn't about just putting technical controls and encryption and good access controls in place. It's about people and process. And if people don't know what they're supposed to do, what they're not supposed to do, you're really not going to achieve much in the way of compliance. Okay, make it business as usual. So walk those 10 steps, make it business as usual. Very important, Colin mentioned earlier, in order to help you deploy the toolkits, we really do provide project support services, and so we're there to hold your hands, basically walk this journey with you without you having to learn from scratch. We've been at it for over 5 years, and we've seen a lot of good, a lot of bad practices, and so we have some experience, we would like to think. And we also offer a service called Information Officer as a Service. So you can outsource your Deputy Information Officer service. You can't outsource the main Information Officer services because the Act says that's the boss, that's the designated head of the organisation. But if there's no one internally that person is comfortable with appointing, there's nothing in the law that says that cannot be outsourced, and we can assist with that. And then training. So a lot of what we do is training. A lot of face-to-face training, a lot of classroom training. A lot of organisations contact us and say, will you come in and run a one-day workshop for our management team? So we spend a lot of time doing that.
Thank you so much for
Thank you.
attending. I know it's quite a heavy subject and a very, very warm room with all these bodies. But thank you so much for the decision makers attending the events and supporting it. Thank you so much.
Thank you.
Thank you from our perspective as well.
Thank you so much.